Evening, everyone. Thank you so much for joining us. For those utilizing ASL interpretation services, our interpreters today are Alefi and Beth. Their display names are on the screen. Instructions on how to pin their video will be in the chat, and as well as CART services.
One quick.
And we're officially opening the CCRB board meeting. Good afternoon, everyone, and welcome. My name is Arva Rice. I use she, her pronouns, and I am the interim chair of the Civilian Complaint Review Board. I would like to call the CCRB September board meeting to order. Sorry, I did that out of order. Would the rest of the board please introduce yourselves, starting with Esmeralda.
Esmeralda Simmons, she, her, an appointee by the public advocate.
Demetrius Carolina, Staten Island, mayoral appointee.
Good afternoon, everyone. Michael Rivadeneira, pronouns he, him. I am a city council appointee hailing from the Bronx.
Right. Good afternoon. My name is Joseph Puma. I go by he, his pronouns, and I'm the Manhattan City Council representative on the board.
Good afternoon, everybody. My name is Frank Dwyer. I'm a police commissioner representative designee.
Good afternoon. My name is Jonathan Darsh. I'm the executive director of the agency, and I use he, him pronouns.
Hi, everyone. My name is Corrine Irish. I am a mayoral appointee and live in Harlem.
I'm John Siegel, mayoral appointee.
Herman Merritt, city council appointee from Brooklyn.
Good evening. I'm Sal Carcaterra, and I'm a police commissioner designee to the board.
Thank you.
Is there anyone?
Is there anyone on the line? Mr. Freeman?
Board Member Freeman will be joining us shortly, as well as Board Member Hogan.
Just so you know, it's still just a little bit hard to hear you higher on the line. If you want to just turn it up just a tad. Thank you.
Thank you. Thank you.
It's for a motion to approve the minutes.
So moved.
A second?
Second.
Are there any changes or corrections to the minutes?
No.
None? Okay, hearing none. All those in favor of approving the minutes as presented, say aye.
Aye.
All those opposed? The minutes are approved. Today, the board will vote on the agency's proposed rules. In July, the CCRB posted its proposed rules and opened the floor for public comment. Last year, the City Council voted to change the city charter to grant the CCRB the power to self-initiate complaints and begin investigations on bias-based policing and racial profiling. In order for the CCRB to begin these types of investigations, the board must vote to change the agency's rules. The CCRB is also proposing to include misuse of body-worn camera footage as an abuse of authority, bringing it into the CCRB's jurisdiction. These new powers will empower the CCRB to address a wider range of police misconduct and improve accountability for all New Yorkers. If the board votes to adopt the proposed rules, the rules will be published in the city record. The rules will go into effect 30 days after publication. Any questions on the procedure or details of the vote and rule changes can be directed to Executive Director John Darsh. John?
Thank you, Chair Rice. The CCRB received notification from the Office of Management and Budget on September 12th, 2022, that the administration would like the CCRB, as well as every other city agency, including the NYPD, to plan cost savings for this year and future years. The target is for the CCRB to cut $706,000 from the current fiscal year's budget and $1,100,000 from future fiscal years. The agency anticipates it can meet these targets without impacting our personnel services or PS budget but I will report back to the board on our plans as we move forward. Despite these targets, the agency is still recruiting to fill openings for several attorney positions in one of the CCRB's core teams, the Administrative Prosecution Unit. The APU handles the most serious cases of misconduct and takes them to trial before an administrative law judge who works for the police department. In addition to recruiting prosecutors for the APU, we are also recruiting additional investigators for the agency. We are going to be holding a virtual information session on CCRB careers on September 21st at 5 p.m., which you can all register for by clicking the link in the chat that Jahai is going to post. This week, the National Association for the Civilian Oversight of Law Enforcement is hosting its annual conference and invited the CCRB to be part of the national conversation on civilian oversight. As the largest civilian oversight board in the country, the CCRB is honored to be a part of the national conversation and help lead the rest of the country as we all work for greater accountability. I'm excited to have been part of a group that presented on the issue of responding to critical incidents earlier today. Other CCRB staff who will be presenting at the conference are Yahaira Alvarez, Bayana Turat, and Amy O'Sullivan. This afternoon, I have a few updates and rules on CCRB operations and how this meeting is going to work. The CCRB expects to have a protest report out in the coming months. Our office is open for walk-in complaints, but it is also possible to file complaints online at nyc.gov/CCRB complaint. That is nyc.gov/CCRB COMPLAINT, or by calling us on the telephone at 1-800-341-2272, or by calling 311. If anyone who is here right now wishes to file a complaint, we have 2 investigators on hand to take new complaints. They are Emma Stardahar and Key Busk. Emma, I think his key is Emma here? Oh, there you go. Sorry, Emma. For this afternoon, if you are online, if you're joining us online and you wish to make a comment, please use the raise the hand feature. We're going to be limiting comments both online and in person to 4 minutes max. I want to thank the staff for their hard work. And I want to thank, again, the members of the public for joining us today.
Of our board members, do any of you have questions of John based on his report? Okay, seeing no questions, I'm going to ask for our Director of Outreach, Jahai Rose, to make his presentation.
Good afternoon. Thank you very much, Chair Rice. Thank you all very much for attending. My name is Jahai Rose. I go by he, him pronouns. Just bear with me for one moment while I share my screen. Okay, can you see my screen? Okay, good. So the Civilian Complaint Review Board is the nation's largest independent oversight entity over the largest police force in the country. The CCRB investigates, mediates, and prosecutes complaints of misconduct against members of the NYPD. The agency is governed by a 15-member board. 5 seats are appointed by the mayor, 5 are appointed by the New York City Council, 3 are designated by the police commissioner, 1 is appointed by the public advocate, and the chair is jointly appointed by the mayor and the city council. The CCRB intakes complaints about police misconduct. Our jurisdiction falls under the acronym FATO, Force, Abuse of Authority, Discourtesy, and Offensive Language. Just a few details regarding the Right to Know Act. The Right to Know Act is a law that went into effect in October of 2018. It impacts police encounters with members of the public. which include, under certain circumstances, officers being required to identify themselves by providing name and other information such as rank, command, and shield number, with some exceptions, explaining the purpose of their encounter with that individual. Uh, Also informing an individual their right to say no when asking for their consent to search that individual's person, property, vehicle, and or home. And under certain circumstances, offering a business card if the with the officer's information that explains how to make a comment and or complaint about the interaction with the officer or any other officer for the matter. Civilians can request the business card in all encounters. This is a copy of what the business card looks like. Now, there are various ways to report police misconduct, as mentioned by our executive director, Jonathan Darsh. You could go to our website, nyc.gov/CCRB complaint. You can also call our hotline at 1-800-341-CCRB or 1-800-341-2272. Remember, if you see footage of misconduct on social media or news media, you can feel free to file a complaint even if you weren't there in person. The hashtag for the agency or the handle for the agency is CCRB_NYC. A couple of additional ways to file a complaint are also by calling 311. You can visit the CCRB's office at 100 Church Street on the 10th floor on New York, zip code 10007 in Lower Manhattan. You could go to the CCRB social media page. We have Facebook, Twitter, and Instagram. You could also file a complaint using mail, which is same address, 100 Church Street, 10th floor, zip code, New York, zip code 10007. You could also file a complaint at any local police precinct. Does not have to be where the encounter took place. Police officers are required to accept complaints at any precinct, and they could also provide you with a complaint form and postage-free envelope. The CCRB is hiring, as mentioned by the executive director, for various positions within the agency. If you have questions regarding information about the jobs or roles, feel free to email careers@ccrb.nyc.gov. If you would like an outreach presentation for your friends, family, neighborhood, local organizations, feel free to reach the CCRB's outreach unit at outreach@ccrb.nyc.gov. You could also reach us, feel free to follow us on Instagram, Twitter, and on Facebook. Thank you.
Thank you, I appreciate it. Do members of the board, well, actually, before I go to that, let me ask, have we been joined on the line by additional board members?
Yes, we have been joined by board member Willie Freeman. Mr. Freeman, can you unmute and turn on your video when you get a moment?
Yes, my name is Willie Freeman. I'm police commissioner designee. I hail from Brooklyn.
Freeman. Do any members of the board have any questions about the presentation from Jahai Rose? Outreach presentation? Okay. Thank you so much, Jahai. We appreciate it.
Thank you.
All righty. We will now enter the public comment portion of the meeting. If you are interested in making a public comment, please line up behind the podium if you are joining us in person, or use the raise your hand feature if you are joining us virtually, and we will go in that order. Please keep your comments to 4 minutes, and Yahira, would you please call on our first person?
Thank you, Chair Rice. First, we will be hearing from Michael Myers, who's joining us virtually.
Can you hear me? Can you hear me? Okay. First of all, I want to respond to the comment on the outreach of the CCRB. I find the presentation, this one in particular, but the former presentations, to be inane, repetitive, insulting. They come off as filler for these meetings. We already know the pablum about how to proceed and how to check on the CCRB for complaints. So I just find these just filler. It's just waste of our time. Second of all, I want to question again: is there any further word or progress on inviting the police commissioner to attend a regular public, open public meeting of the CCRB, so the public can hear from her and hear CCRB question her about her support or lack of support and backing of the CCRB's investigations.
Thank you, Mr. Myers, for your comment and your question. I'm going to ask our executive director, excuse me, to respond to the presentation about our outreach director to see any feedback that he has on that. And in terms of your recommendation to invite the police commissioner, our board has been in conversation about the feasibility of whether to extend that invitation. And that is an ongoing conversation that we are having, and we will most assuredly make a presentation back to the public on the ultimate decision that's decided on that recommendation.
What's taking so long?
Mr. Myers, I know you have been very involved in the issue of civilian oversight of law enforcement in this city for many, many years. And I have a huge amount of respect for the work that you do and have done for this city on this issue. But there are also people tuning into this hearing who may not really know what the agency does. And so when we have this outreach presentation, it is not really aimed at someone such as yourself, who frankly probably knows more about civilian oversight in the city than I do. It is aimed at someone who might not realize what they're tuning into. It's supposed to give people the baseline so that they can participate in this meeting and understand what this agency does. And so, with all due respect, I think I know how much work Jahai does on his presentation, and as his boss, I'm proud of the work he does and his whole team does. And so I think, and while I understand it may be frustrating for you, I think it's an important part of this meeting and the work that we do.
Jahai, can you let us know who is next? Yahaira, can you let us know who is next on the list?
Next we have Daniel Heredia joining us virtually.
Hello, my name is Daniel Heredia. I'm from Council. Hi, my name is Daniel Heredia. I'm from Councilmember Farrah Lewis's office. I am making a comment on behalf of our team with constituent services here at District 45. Recently we had a person come into our office wanting to make a complaint, and we were informed that the web form to making a complaint is a little bit difficult to use, especially when not all of the details about the person, about the police officer who the complaint is made about in this incident is known. So I am wondering if maybe it could be answered, or rather if hopefully later down the line there can be a discussion on how to make a complaint when some of the information about the NYPD representative or officer who the complaint is about, if not all the details are known, somehow to be able to understand that still there's a pathway for an investigation to take place within that precinct to figure out where that situation took place and find which police officer was responsible, even though if the complainant was not able to get a name or other identification. This is especially true as in the constituent case that we dealt with a couple of weeks ago, where the NYPD officer perhaps was off duty, and thus there is more of an impetus to make a response on the behavior of a police officer even when they're off duty and make possible abuse of power, but still being able to identify who that representative is and to make sure that they are able to be identified during an investigation. So again, just to succinctly put it, our office is concerned about the way that complaints of police misconduct are handled if not all the details about the police officer is known at the time, and we would like to be able to reassure our constituents who do make complaints with the Civilian Complaint Review Board to be able to know that the investigations can still be done in a productive and fulfilling manner, even if not all those details are had. So I rest my time and thank you so much for this public hearing. Thank you.
Thank you so much, Daniel, for that thoughtful question, and I'm going to turn it over to our Executive Director to respond.
Thank you, Madam Chair, and thank you, Mr. Heredia. So there are two issues that I want to address from your question. The first is a civilian doesn't need to be able to identify the police officer or officers they had an interaction with in order to file a complaint. One of the things that our investigators are good at is taking the information that we do get from a civilian and looking at police paperwork, looking at body-worn camera footage, and figuring out who the civilian making a complaint interacted with. With regard to the actual form, we're in the process of revising the forms. And so this is something that I'm going to bring up with the team that's working on that to make sure that it's clear that you don't need to fill out all of the identifying information about a police officer in order to file a complaint, that you could just give the basic information about what you know happened in order to file the complaint. And then our investigators will contact you to get a statement from you and do the follow-up work on the back end to identify officers. I just wanted to clarify one other point. The CCRB has jurisdiction over members of service who are either on duty or who invoke their authority as police officers when they're off duty. So it may be that we investigate, when we get the complaint and investigate the case, we determine that in this case, we don't have jurisdiction because the officer did not invoke their authority as a police officer. And in that case, we will refer the matter to the NYPD, where in all likelihood, IAB or maybe another investigative unit will handle the investigation. Mm-hmm. But I thank you, Mr. Heredia, for bringing these matters to our attention.
Mm-hmm. Thank you so much, John, for that clarification, because that was, I had that question in my mind as well. Michael?
Madam Chair, I just have one question regarding what we had practiced before the pandemic, where there were investigators who would go to council members' offices, and I'm not sure if we're engaged with the council again in trying to resume that practice. I know that there was a couple offices in the Bronx and in Brooklyn that hosted investigators on set days during the month, and I would like to see if we can get back to that practice, so we can create another access points for folks to complain.
So I don't believe it's resumed at this point, and so I will talk to Yahira and Jahai when this meeting is over about trying to get that restarted.
Mm-hmm. Thank you. All right. Jahira, who's next on the list?
Thank you, Madam Chair. That concludes our virtual participation. I just want to make a personal note, Daniel, we'll be reaching out to you shortly to hear more insight and feedback. And we also want to thank the Office of Assemblymember Heidman, the Office of the Manhattan District Attorney's Office, the Office of the Bronx Borough President, and the Office of Congresswoman Grace Ming, and as well as the City Council Member's Office of Kristen Richardson Jordan. Thank you all for attending, and I move it to you, Chair, for any folks in the room that would like to have comments.
If there's anyone in the room who would like to make a comment, if they want to come to the microphone.
Sir, if that's you. You can go.
Hello, how are you?
My name is Andrew, and I came here several times before, and I mentioned that I've been attacked and followed around by cover-up people and law enforcement. The flyers that I gave you shows you that Philando Castle, he was executed by law enforcement. How long was law enforcement following him around? According to the New York Times, for 13 years. I put this online in 2013 that I'm being followed around by a terrorist organization. This is cover-up people and law enforcement. They attacked me in Chicago. They put me in the hospital in 2015. 2018, they did the same thing here. They attacked me and put me in the hospital. When I filed the complaint, I told the investigator they took down the cameras off the building. They had erased the video. They did this to a guy in Chicago named LaQuan McDonald. I've been asking for help like several times, and I've been asking to reopen the investigation. So far, I heard nothing. And law enforcement keeps throwing me inside the sidewalk. And in my friend investigation, I found out that when law enforcement does that, it's because law enforcement is scared of you. That's why they toss you in the sidewalk. Now, why the sidewalk? Because law enforcement don't want you to testify against them. They did this to 2 people in New York City. Adrian Schoolcraft, Nella Gomez, 2 NYPD officers in NYPD. Why? Because they had evidence against cover people and law enforcement. When law enforcement is exposed, they toss people in the sidewalk like they did to me a couple of times. Obviously, they're scared of me because they can't push me. They can push other people, O.J. Simpson, Julian Sands, and Edward Snowden. So I need help in exposing these cover-up people in law enforcement. I came here several times before. Has anybody looked at the video that I sent to the CCRB that they tossed me in the sidewalk against my will? Has anybody checked out the video that I emailed the CCRB the last time, March 5th, 2022?
What's that question today?
That's the question.
All right. Thank you for your comment, and I'm going to turn it over. I know that you joined us that you were with us last month. So I was just call on our executive director to respond.
So I will check on the status of your complaint, sir.
Every time I go there,
So if you wait until the end of the meeting, I will sit down with you and we can talk about your case, and I'll tell you and give you an update.
Take a nose at my shirt. Police ambushed me in 2 states, front and back. Okay? Every time I come here, it's the same story over and over again. I'm gonna look at it. Meanwhile, cover people in law enforcement and the thugs keep attacking me. This is a court case. The court case is called Socialist Workers Party versus the Attorney General. Law enforcement used thugs right here in New York City. The court case was right here in New York City. They used thugs to break into people's homes and businesses. That's cover people in law enforcement. And they make people homeless and get people fired from their jobs. Colin Kaepernick, Councilwoman calling cops terrorists, Mayor Asia Brown, they like to terrorize people. The point is, they can't push me, so they're scared of me, because they could never push me, ever. People that they could not push in history, Martin Luther King Jr. and Jesus Christ. 2 people that could not be pushed, they couldn't shut their mouths, and they were murdered, like me. I can't shut my mouth. You punch me in my face, I'm gonna let the world know that you punch me in my face. If the president of China punched me in my face, he gets the same treatment. Nobody's special. You want to attack me? I'm going to talk. I don't need to use violence to get my point across. It's better to be like Martin Luther King Jr. and use his words like Jesus Christ. So that's my example. So I need to come down here next month and next month and next month and keep asking the same question. This doesn't make sense.
Understood.
All right, thank you.
Thank you. Is there any other member of the public who would like to make a comment if they want to step to the microphone? Any other members? Seeing none, we will move to our old business. Pursuant to the City Administrative Procedure Act, the CCRB published a draft copy of our rules 30 days in advance of our July public board meeting. During that period, the CCRB accepted public comments, and on July 13, 2022, the CCRB held a public hearing to discuss it. After careful consideration of the public comment, the CCRB established the final version of the new rules on our website on Thursday, September 8, 2022. At this time, I would like to take a final vote May I have a motion to approve the board's revision of multiple sections of its rules?
Can we discuss the
Yes, and the discussion will definitely follow. Absolutely. The proposed changes, among other things, will allow the agency to begin self-initiating complaints and investigating bias-based policing and racial profiling, and simplify the language related to dispositions. Can I have a motion to? May I have a motion to take the final vote today?
So move.
Thank you. I will now open it up for comments from the board members. Frank?
Sure. So I have a number of concerns, many of which can be ameliorated or addressed. First, as I read the document, I find the whole incubation of how we get to these things very odd, because we're not allowed to discuss them in advance, and yet they just sort of appear. And I'm not saying that's the fault of anybody here, but it's just very hard to get. I think if we had a way, if our legal counsel could find a way for us to be involved early on, concerns could be addressed early on. So one of the things I noticed is there's a move under the guise of making things clearer for civilians to change unsubstantiated to unable to determine, and also to change exonerated to within police department guidelines. Now, I understand why that might be clearer for civilians and police officers. It might be very helpful, but there's a simple way to do it that doesn't cause issues. And that simple way is to put unsubstantiated, parentheses, unable to determine, exonerated, parentheses, within police department guidelines. So you would say, what's the difference? Well, the first difference is that academics, scholars, members of the court, members of the board, members of the public like to compare apples to apples. And this board cannot just vote or tell staff, or staff cannot on their own, just to decide to go back and take 4 decades of data and change something where a board voted exonerated and change it to within police department guidelines, because the panels that heard those cases didn't vote for within police department guidelines. They voted for exonerated. So if we leave the categories what they are, which is unsubstantiated and exonerated, and then put after unsubstantiated parentheses, unable to determine, exonerated within police department guidelines, then people who are doing research, people who are doing comparisons will have apples and apples, not apples and oranges, and it will be much more useful over time. But as I say, and I would strongly encourage we not go back and claim that we can recategorize 40 years of data when in fact the panels and boards didn't vote for those things being the same. They are different words. In the second area, it says remove complainant unavailable and put in unable to investigate. Well, I think I understand what that's about. I'm not totally sure, but if we just have a category called unable to investigate, then that leads to broad inquiry. Why were you not able to investigate? So again, here it seems to me we've used complainant unavailable for, I guess, 4 decades. Why don't we just put a colon or a open parentheses, close parentheses, complainant unavailable, unable to investigate. And again, you would maintain apples and apples. That's on that category right there. Madam Chair, I don't know if, I have some other matters I'd like to discuss, but I don't know if you want to open that specific issues for board discussion and then we go to my second and third, or whether you want me to continue.
I actually thank you for that. I think it would be best if we did take them one by one. And so the issues that you brought up around unsubstantiated and exonerated, I would like to hear any other discussion from board members on that first, and then we'll take them in turn.
I can comment very quickly. I really appreciate the board moving to language that is more understandable for civilians, because I do think, and people have commented in our board meetings that they don't know what substantiated means, they don't know what these terms are, and that we are talking a language that they don't really understand. And in the effort to be more transparent, you know, and just clearer, I really think these rules are a good step forward. I think it is a good question about whether it is retroactive, and I would like to know that as well. Are we going to go back and change things, or is this just moving forward?
John, it is a prospective change. We will not be changing the data that we have what the board already voted on.
John?
So it seems to me Frank's concern is easily resolved by dropping a footnote on the board's statistical reporting, and any researcher will see that and can account for it, and it doesn't seem to me it should be impose much confusion.
Thank you. Sal, did you have a comment?
Yeah, as far as Frank's comments on both, the definitions, number one, I don't really see the reasoning, but I agree with Frank. If you're going to do that, then why not just go with what we've done for all this time and add the words, as Frank said. Same thing with complaint and unavailable. That leads open to all kinds of questions down the road. Why you complaint unavailable, just to take that out. I think it's important to know why you couldn't investigate a case, and I would not do one without the other. So those two changes or suggestions that Frank mentioned, if I'm voting on it, I would vote yes for those with those additions, and I would not vote for that without them. I just don't see the need for that, and I think it creates more problems. And if you want transparency, put them both. It gives answers to both things, the way we've done them, and for the civilians to understand them better. It gives us both, and I don't see any downside to that. Thank you.
Any other thoughts on the first issue that Frank raised, his first concern? Okay. No other? Okay. And then, I don't know if anyone, so you were saying basically, Sal, that you agree with both of these pieces of the comment in terms of the definition, being able to put the slash and keep the title, and then also being able to compare the apples to apples to apples, and rather than apples to oranges. And then was there another piece of those first comments?
Well, the second part was this idea of removing complaint unavailable, so that when the public looks and they see we didn't follow up and we wrote unable to investigate, that they have an insight why. We couldn't investigate because we couldn't find the person who was the alleged victim, and there were no other avenues at the time. So, in fact, what I'm suggesting by putting unable to investigate or complaint unavailable / unable, we're actually providing the public with more information, which is totally in the spirit of transparency that we often speak about.
Mm-hmm. Okay.
I would just say, and you can correct me, Mr. Darsh, if I'm wrong, I don't think changing that label prevents us from giving more detailed information as to why we were unable to investigate. It's just that initial label might be changed, but we can still offer in reporting breakdowns. Is that right?
That's correct.
Okay. So
Tell me the reasoning why. I mean, you would think everybody wants more, everybody wants transparency, explaining exactly why you couldn't investigate the case. Just have it and add that in, and it makes it crystal clear. I just don't see why you wouldn't want that.
As we, if and when we move to self-initiated complaints, complainant unavailable will not be able to capture all of the reasons why a complaint was not able to be investigated. So I think I like complaint unavailable too, because it's very obvious, but there may be other reasons that will fall under that category if in fact these rules are passed. So I think that it does require a change in just having not only complaint unavailable, because we're going to come across other circumstances in self-initiated complaints that where complaining is not an issue.
Very helpful. Any other thoughts or opinions on the first 2 points that Frank raised? Okay. We would like to hear the third.
And just before I go to the third, I would just add the other thing within police guidelines. You can make an argument, I guess, that we always rule based on police guidelines, but in fact we don't. We often rule based on court decisions. We often rule based on the city charter. Sometimes we look at each other and say, you know what? As far as we know, though the patrol guide is 2,700 pages long. Last time I checked, there's nothing to our knowledge in there in the police guidelines, and we have to make a decision based on law, common sense. So to categorize it as within police guidelines, as I say, you can make an argument that in the end the city charter says protect life and property or something, but the reality is it's often more or different than just merely within police guidelines. This is a small thing, and again, this is a good example of why if we can find some way in the incubation process of these proposals, I would have addressed this then, because it's a rather small matter, but it's not insignificant. In the bias-based policing, it says an act by a member of the force. Well, the police department in New York City has not used the term force since, I believe, the 1960s or early 1970s, and there was a specific reason that it made that change. So I think some would argue it's not a substantive matter. I would just ask that be struck from the text. To the best of my knowledge, nowhere else does anything say the force to refer to the police department. It's the department. I have a concern about the definition in active bias. And a lot of the definition, I think, is very solid. I'm not sure whether it was taken from the city council or whether folks here put it together. I think there's a lot of very solid stuff in there. But the last thing in there speaks about conduct that otherwise shocks the conscience. And conduct that otherwise shocks the conscience, well, whose conscience? Donald Trump's? The Dalai Lama's? Pope Francis? I mean, we're trying to make things that will be used essentially as matters of administrative law. And while it is very hard to get the objectivity in any matter, we try our best to define it. Now, I think it's a fair statement, and I say this in my heart. I think everybody up here are people of goodwill and good conscience, and we differ sometimes, but I hold them in high regard. But part of the reason we create documents like this to permanently enshrine, indoctrinate, admittedly subject to change, is because we don't know what a board will look like in 6 months, a year, 5 years. So I think it's important that phrases that are open to such broad interpretation, we'd be very careful about including them. So I think the conduct should be specified, and that terms like conduct that otherwise shocks the conscience, well, I don't think that's the... We had a man in the 1950s in America who ruined hundreds of lives. We all know who it is. His name was Joe McCarthy, because it shocked his conscience that in the 1920s, during the Depression, somebody went to a meeting of a political party that he didn't like. We can say that would never happen here. Do we know that? So the idea that we would take up an administrative prosecution based on shock to conscience, I think we should be able to name what it is, name that it's clear bias, name what makes it severe bias. I'll stop on that point.
Thank you.
I think that there's too many names to a list.
that law enforcement do,
Excuse me, sir. We're not in the public. That's okay. We're just not in the public portion of the meeting. So thank you. We're just having a conversation with the board members. So so you're asking for a strike of the use of the force because it's an antiquated and an antique term.
Exactly.
Exactly. And then you talked about the conduct that shocks the conscience. And so I wanted to hear any further thoughts or opinions on those two facts.
Yeah, I just think whether it's used there in that sentence, shock the conscience, or, you know, we do cases and we go back and forth with things. And why would we start out now with something that is so broad when we could narrow that down and be a little more specific? And maybe obviously you can't cover everything, but that to me is we're starting off from this big room filled with stuff, and we're supposed to interpret what shocks me as compared to John or other people on the board, and that's just not fair. It's way too vast. It's a broad brush, and I would strike that. And you need to come up with something that's more pinpoint than that, and it can't be obviously all inclusive. But this just goes 180 degrees the other way, and I don't know if we want to start off a document with that.
Yeah, I would just say that, so the definition is, that term, I see it in the definition of severe active bias, where active bias is earlier defined in the definitions, and it's very specific. Shocks the conscience, to me, actually has a very specific legal definition, and I think it is, and I think, I assume that is incorporated into this definition because that term is used in case law, and it actually isn't easy to get to that standard. So I don't think that there's a concern that it's going to be overbroad, or it actually, I think it just is meant to be something we haven't conceived of, and I think it's okay to have it in because there is case law that has dealt with that term and how it should be and how it should be limited.
I was going to say the same thing, but go a little broader. I was amused when I saw it. It's I wish Matt was here because I am not the case law expert to tell you exactly what Supreme Court case that came from. A shocks the conscience comes right out of a Supreme Court case, a criminal justice Supreme Court case. It's very similar in terms of their idea of trying to express something that is not normally expressible, not easily expressible. When they said that you can know pornography, you know it when you see it. These Supreme Court quotes are given to us in the legal community to serve as a guide into an area that's not easily expressed or broad, but needs to be specified in a way that many people would understand exactly. It's a committee decision, by the way. It's never supposed to be an individual. What shocks the conscience? So I do believe that putting it there may serve our purposes because it allows us to look into things that are not specifically designated as a major bias crime, but maybe somebody gets ultra creative. We don't need any more creativity in the area, but people can get creative. But we have not listed every single thing that could happen. So that's my response to it. I can understand because when you're in law school, you say, what does that mean? Well, exactly. Everybody is going to say that. Unfortunately, it's very familiar to the ears of attorneys.
I have just a question. I have a question that the answer which escapes me as I'm looking at it. What's the difference procedurally of an act of bias and a severe act of bias? What's the consequence of something being brought as a contending that it's an act of bias versus a severe act of bias? I don't know if Matt's here and can answer that. I just don't know where it leads in these rules.
So I think it may depend on what the matrix eventually says about severe active bias versus active bias. But right now, the way the matrix is set up, it is extremely harsh on just mere acts of bias.
So from our point of view, if it's charged as an active bias, a severe active bias, it doesn't make any difference. The case gets investigated and a hearing panel makes a recommendation. The difference is where it ultimately leads as a penalty.
Yes, that's my understanding.
Okay, thanks.
So you're saying, John, that when this case comes out after it's investigated, okay, it comes out of investigations, it goes to the panel, is the investigator making this determination?
I don't think so, but the way I take it is...
We're here, your attorneys, you have court decisions, and now a panel reviewing the case is going to get this from an investigator. And not knocking the investigators, but they're young kids, they don't have a ton of experience, and this is really far-reaching and very severe, and who's making that call?
So the racial profiling cases aren't, so just to break it down a little bit, when cases are coming through regular investigations track, there are investigators of varying levels of expertise who make those recommendations in conjunction with squad leaders who are very experienced and attorneys who, in this case, Heather and Suzanne, who you guys know are our current deputy chiefs of investigations, and Monty is here now. He's chief of investigations. These are experienced attorneys who are assisting the investigators in coming and making those determinations in the cases that we see today. But on the bias-based policing cases, we understand that these are extremely complicated and difficult cases, which is why we've set up an entirely different unit where there are no investigators assigned to racial profiling cases who are lower than a level 3 investigator, right? And then we have investigative attorneys actually assigned to the unit. So I'm attacking the premise of the question a little bit to stick up for my investigators, but I do get it, and I want to assure you that the racial profiling unit, like, you will be getting cases that have been investigated by very experienced investigators, investigative attorneys, and then the decision will be made by attorneys and investigators working together and submitting it to the board. So, like, you will see those cases, but they will be different from a regular force investigation or abuse of authority investigation.
Do you have any different protocols set up for the investigative process in those cases? Any different reviews by the supervisors as the case is progressing? Is there anything that was added in training and in steps and to acknowledge the severity of this and how it goes about to get to that conclusion?
So I don't think we've added, because it's not the same investigative process. It's a whole different unit and team, and frankly, they're using different tools. And so, like, we have a data scientist, and we're going to have a data analyst. It's a very different process, and I think it warrants bringing Darius back to give another presentation so that the board can see and the public can see how we're going to be handling these types of investigations. I don't want to be just doing it off the top of my head right now.
I also think the rules have to be passed first, right? And then the training on the rules after the rules.
So we have been like the unit, we have people who we've hired, and they are building the unit, and their goal is to be ready so that if these rules pass, and then we publish the rules, and then 30 days later the rules go into effect, when we get a complaint, we will be able to investigate it. That is the goal. So we are ready to be online when this happens.
Go ahead.
So two of my colleagues have pointed out that the term shocks the conscience is a term of law based on case law. But I also, one colleague clearly said, but she's not sure what exactly the definition is, and the other colleague didn't comment whether she knows the definition or not. And over the next months and years, panels are going to meet, and when they meet, they're not going to know what that definition in law is. So it leads me to think about something as simple as a burglary statute. So a burglary is when you enter or remain in a building, blah, blah, blah. But before that or with that, they always define burglary. They always define building. So they say a building is a house, a commercial, oddly enough, a van that somebody uses for their business is actually considered a building under the burglary statute, so a plumber or something. So, my recommendation here is that if we are going to say that this is a defined concept in law, we should add either right there or earlier on the definition based on either the Supreme Court ruling or whatever that which carries the support of the judiciary, because otherwise we're going to be sitting around not working off a legal definition. We're going to be working off of everybody's opinion of what that means at the time. So that's easily fixable. I mean, this is, as taking out the word force can be done tomorrow, as adding this definition can be done, tomorrow. And I'm happy to make motions on these things if it serves parliamentary procedure. But to just say we're going to leave it in, yet not know what the legal standard of something regarding conscience of this regard, I think is a mistake. It's too subjective.
Mm-hmm. Mm-hmm. Thank you for that restatement. And I was just clarifying on the various topics that you've brought up. If we should, I actually wanted to hear all of them, and then we will go back and figure out which ones that we want to make a motion on and see if we wanted to make a vote about it being part of the amendments to the rules. So I have 3 at this point, and did you have a 4th?
The section that speaks of adding misuse of cameras, body-worn cameras, Mike, I have a concern there, and if I understand, and please let me get clarity on this, are we listing this as an abuse of authority? Maybe the executive director could clarify that.
I'm sorry, Mr. Dwyer.
The inappropriate use of body cameras, we're going to categorize that as an abuse of authority?
Yes.
Okay. So the issue, and we've danced around this in some panels, is abuse of authority, the definition given, and the common sense use of the words that one abuses their authority when they do something. But the definition of misuse of cameras that we have includes when someone doesn't turn them on. That is to say, an omission. I think if we're going to start including omissions, as well as commissions, which we've always included, then that needs to be clarified and maybe even examined in terms of the city charter as it exists, because at least in my experience in examining cases, what we look at is what the officers have done, not what they have failed to do, which, by the way, doesn't mean for a second I don't believe that if an officer fails to act, that it's not a disciplinary matter. It can be it can be a disciplinary matter for which he or she should be fired under the right circumstances. But as I'm reading the structure of our documents historically and the law, we investigate acts, not omissions.
Thank you. Did anybody have a comment on that comment?
Yeah, I don't see it the same way. There are lots of failures to act and omissions of action that we recommend discipline now as an abuse of authority.
Failure to obtain language, interpretation services. I don't have a mic that works, unfortunately. Yeah, I mean, an example of that would be like failure to obtain language access services is something that we plead. There was another one that came to mind. Oh, failure to process or to give a right to know act card is one that has cropped up in cases over the last few years. So yeah, those are examples.
Yeah, Joe, I would agree with you, although I think at least in the latter, I think the city council specifically authorized us to do that, didn't they?
Yeah,
I think that was a specific legislative authorization as opposed to us taking the power ourselves. But I could be wrong on that. I could be wrong. I think the last thing I'll raise for the moment anyhow is I'm concerned about this investigation of people. I mentioned going back 5 years, which is fine if the person is an active officer, but it also seems to say that we're going to invest people who are retired, theoretically dead, and the question is, I mean, there's all sorts of matters of unintended consequences here. What do we do with that? We've invested. The person has no right to a trial after that if it's substantiated. They can't say, I would like so you substantiate something from 4 years ago against somebody who lives in Florida, and he says, I would like an administrative trial to prove I'm innocent. Well, first, he's going to have to hire lawyers, because unions no longer represent him, et cetera, But the reality is he's not entitled to any method of adjudicating this finding. And I don't know, that just seems most peculiar to me. That it sort of seems to go against it's almost like the district attorney indicted you and you say, I want a trial, and we're going to say, oh, you're not entitled to a trial because you're retired. That's a most peculiar administrative reality. Mm-hmm. Particularly, I would add, because then, as I'm aware of happened once in a case where somebody was retired, somebody sued, and the corp counsel said, we're not indemnifying you because there's a CCRB case substantiated against you. And he said, yeah, but they won't give me a trial to prove I'm innocent. So these are not simple matters. Mm-hmm. Mm-hmm.
So your concern is about the ability to investigate members of service back for 5 years, right?
Well, it's not per se 5 years. I mean, there were circumstances where you'd want to investigate 20 years ago. I would think it'd be the district attorney, somebody alleged to kill somebody. The issue is somebody's retired or even theoretically dead and somebody's made this allegation. Are we going to open an investigation for somebody who's retired 4 years or something, mm-hmm. particularly when they don't have a route within due procedure to, if it gets substantiated, to then ask for a hearing to clear their name.
Right, understood. Before I hear comments from the other members of the board, I saw that there might have been a clarifying question over here. So if you all are asking for a clarifying question, I'm sure we probably also had it as well. So John, were you able to respond? No? Did you? Okay. So then if there isn't a clarifying question for the full board, John, I wanted you to, if you could, just to clarify what the rules are actually saying in regards to how far back that you can look at for these cases, 5 years, just exactly so we're.
So the charter resolution, the charter change did not give the CCRB jurisdiction over new categories of members of service. We have jurisdiction over sworn members of the NYPD. So if someone is no longer a member of the NYPD, we have no jurisdiction over them. And so we're not going to open an investigation against someone who is a sworn member of the who is no longer a sworn member of the NYPD.
Very helpful. Does anyone, Dr. Caroline?
As one of the non-attorneys on this wonderful board, is the nature of this rule referring to the spirit of the investigation of CCRB? Is that the goal here, that we do our due diligence with regard to investigation? Is that the nature? I guess that's the question that I'm asking.
I think you need to clarify that.
Again, not being the attorney, I don't know if I'm wording that the way in which you intelligent attorneys would do so, but I'm thinking that the nature of this is so that we could do our due diligence with regard to the any accusation against an officer.
Yeah, I think that we have to put forth rules consistent with the charter, which gives us the authority to investigate past professional conduct by members of the police department. So I do think, yes, this is trying to capture what that means and be more specific than what's in the charter.
Thank you.
I'll just point out that this document, which the mask makes my glasses fog and then I can't read it, probably part of the grand conspiracy to censor me. Huh. It says, may conduct an investigation of past conduct in the course of performance of official duties by a current or former member of the police department. By a current or former member. So if, as the executive director explained, it's our policy not to open up against former members, then I think this needs to be corrected.
But that language is straight from the charter.
So then this is a radical change. We are now authorized to conduct them against former members?
Yeah. So the charter authorizes that, but the charter makes no provision for any of the other types of follow-through that would be needed to do those types of investigations. So we are trying to develop the rules in a way that allows us to investigate the cases, as Reverend Carolina said, in the spirit of what the charter would like us to do, that actually is still doable.
But John, according to what Frank read that, I know what you said, but there's nothing based on that statement that prevents you from investigating a former member of the service.
But there's
black and white. I know what you said, but what I'm saying is it states that you can do that to a former member of the service with all the things that Frank said, with no recourse. They could basically substantiate an absentia or something, this person, you could get substantiation, they're retired, living somewhere else with a job, and that could affect their life, their livelihood, and they have no recourse whatsoever.
So,
is that true, what I just said?
So, if the board chooses to do that in concurrence with what the city council already did, then yes.
Okay.
But I can tell you there is no plan to investigate.
I know what you said, but you answered my question. The answer is they can.
There's nothing, the way I'm reading it, Sal, there's nothing that prevents it, but there's also nothing that enables it either, right? So there's nothing that we have that enables us to go after, I shouldn't use the term go after, to go forward with a claim against a member of service who's retired. We don't have the infrastructure to do that because that's not what we do.
I know,
so it doesn't prevent us from doing it. But
I hear you, but if you were retired, you wouldn't want to be on the other side of that with that happening to you. I can assure you no one on this panel or in this room would. And that's my concern.
I'm just trying to figure out if we were to, the language itself comes from the charter. The language, okay, got it. I'm just trying to figure out, okay.
Yeah. So I think we're trying to add Darius to the Zoom, or to the Teams meeting, so he can explain the difference between the two sections in the charter.
That would be.
I thought what we talked about last time you made the presentation was, though we may be able to investigate, we can't really discipline.
Correct.
Okay, that was,
So. When you publish a finding, right?
Yeah, I don't even know. I don't know. Is that true?
You can't discipline a retired member, but there's nothing preventing you from publishing this whole finding without any recourse from that member.
No, you're saying.
But I guess the question is, we're trying to figure out where to allocate our resources. Why would we put so many resources in investigating people who we don't have authority to discipline, as opposed to current members of the force who may be engaged in racial profiling or acts of bias? I mean, to me, that would be the priority, the overwhelming priority. And we're trying to thread a needle where we can't be inconsistent with what the charter says, but we also are aware of, our limitations.
Madam Chair, Darius is gotten upgraded. If we can.
And I would just add right before.
Hi, I think, can you all hear
That we want the public to be aware of what we do find. That is our job, to do our due diligence. And to hell with somebody's retirement if the public or if these investigators, find some wrongdoing. It is our responsibility morally to publish those findings, period.
Darius, I understand that you have joined us.
Yes, can you all hear me? Can you hear me?
Where we are in the.
Yes, can you hear me?
Darius, you're a little muffled. Can you speak closer to the mic?
Oh yeah, I'm trying to sit as close to my mic on my computer as possible. Can you all hear me? Hello? I don't know what.
We can kind of hear you, but you're very low. And the other people participating virtually, we can hear fine.
Yeah, I'm not sure. I'm sitting on my my laptop. I hear you all very well, but I don't know why. I don't know what's wrong with my microphone. Let me.
Can you hear me better now?
My goodness, yes.
Okay, there we go. I switched the microphone. All right, sorry about that. All right, so this has been a really interesting discussion to listen to, but I was eager to interject because I think there is a little bit of confusion, and I understand why, because I think the city charter is a little confusing, or the charter amendments are a little confusing on this, but there's a little confusion, I think, over the kind of two areas of jurisdiction that you all are discussing with respect to the bias policing stuff. So I think the first one is the Section 440, the amendments to Section 440, which have now made bias policing and racial profiling a form of abuse of authority that the CCRB has jurisdiction to investigate under its FATO jurisdiction. And so that means, if a civilian files a complaint and alleges profiling or bias policing, we will investigate it as we do, other forms of FATO. And for those investigations, the definitions in the rules that are relevant are the definitions for bias-based policing and racial profiling. The definitions for active bias and severe active bias, those apply to what we call the past professional conduct investigations, which are Section 441 of the Charter. And I think the important thing to understand about those investigations is, and I think this gets to the concern that was raised by the board about, officers not having a right to kind of answer the allegations, and if somebody's retired. Those investigations, the past professional conduct investigations, will only be triggered. In other words, we will only open such an investigation if that officer has already been found in a prior investigation, whether that's by the CCRB, the City Commission of Human Rights, Department of Investigation, or a court, if one of those other entities has already made a finding, a final determination that that officer had committed an act of bias. So in the case of a retired NYPD officer who was found to have committed an act of bias, that finding would have been pursuant to a full investigation in which that officer would have already had an opportunity to, respond to the allegation, and there would have been a full investigation and a finding made about that past act of bias. Once that finding is made, what CCRB would then be investigating is not that act of bias. We would then be investigating this officer's on-the-job conduct to determine if that single act of bias was part of a larger pattern of bias. And in that investigation, and I think the charter says this, the officer would have an opportunity to respond in writing, I believe, to any findings that we make about, his or her past professional conduct. So I don't think it's accurate to say that if this was a situation involving a retired officer, that officer wouldn't have the opportunity to respond to the allegation, to say that they wouldn't have any sort of due process. Now, again, going back to this question of active bias, severe active bias, those terms are only used in section 441 of the charter as it applies to these past professional conduct investigations. So that is not going to be something in a regular profiling or bias policing investigation where a civilian files a complaint. Those terms are not going to be what we would use. What we would use are the definitions for racial profiling and bias-based policing, and those definitions come both from city statute, administrative code, and from the NYPD's own racial profiling definition. So that's where those terms come from. And I guess the last thing I would say, and I'm happy to answer questions, is on this shocks the conscience question. As I think Board Member Irish and others noted, that term is a term that the Supreme Court used in a very, I think, well-known police misconduct case called County of Sacramento versus Lewis, which you can look up. So I think I would agree with Board Member Irish that it is a pretty well-established legal standard. It's not something that kind of was created out of thin air. And it is meant to, I think, encompass really egregious misconduct by police officers that doesn't rise necessarily to the level of the other categories we put in the proposed rule, bodily injury, criminal conduct, but other forms of egregious misconduct. So I'll stop there, and I'm happy to answer any questions.
Clarification and response on not only the issue that we were just discussing, but the full range of questions that were raised. So that was very helpful. Does anyone have any comments or questions to ask of Darius before we continue the conversation? Over Carolina?
Just County of Sacramento versus whom again?
Lewis, I believe. I think it's a Supreme Court case from like the late 1990s. I'm sure we could send a copy of it if people want to read it.
And its name. Name.
I think that Lewis.
Lewis?
Thanks.
Darius, can you put chat so that everyone can have it?
The name of the case, yeah. Let's see. How do I do chat on this thing?
All right, and she'll put it in that.
Okay. Yeah, I'm not as skilled with WebEx. Oh, I see it. I'll put it in there. Okay.
Or would it be acceptable? Oh, would it be acceptable to Mr. Dwyer if that case is just attached as an appendix to the rules, or I don't know.
Well, I just find it acceptable if the court's definition of what it means is put in, because I mean this is a phrase that is so subjective, right? But we can instantly not make it subjective by just adding. You know, you could add it as a footnote, or I would rather add as a term of definition. You know, the Supreme Court has ruled shock to conscience means blah 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 in, you know, San Diego versus Lewis. So, you know, but at least the definition that allows people not to go by their own feeling about, well, that shocks my kind. Well, what's the standard? And I realize in the end there will be subjectivity in the standard.
So if we are going to change the definition,
I have a question. If we make any changes, we have to go back to the process, right?
correct.
That's what I wanted to.
The only exception would be for something that is ministerial, like a typo.
If we're taking out the word force, which I don't really have a problem with, is that considered ministerial, or is that something more involved?
And replace it with
Service.
service. I think that's ministerial.
I would agree with Board Member Simmons that that is ministerial.
Before we
Any of the footnotes that have been proposed, would that be considered ministerial, or that would go back?
Yes.
I have just two comments I wanted to make for the record. One on the severe act of bias and the definition that includes otherwise shock to conscience. This would have to be something that, if it involves death, physical injury, serious psychological or economic injury to the victim, subjects the victim to the act to demeaning, degrading, or humiliating treatment, or involves criminal conduct, sexual misconduct, and threat of violence, it's already within severe act of bias. So we're talking about something so hypothetical that it doesn't fall in any of those categories. And I, for one, am not willing to limit the definition of severe act of bias to what we in our imagination can conceive of, because history tells us there are inconceivable acts of bias that may not fall within those categories. And I'd like to see this board, in its wisdom and its judgment and its discretion, have the right to investigate such an instance that none of us can think of and none of us wants to, but it's possible. Two, I want to second the point that Reverend Carolina made. Yes, the CCRB cannot recommend discipline in the employment sanctions that we recommend to former police officers. But I do not think that means that we can't investigate and comment on acts of bias or patterns of bias by former police officers. Indeed, in the report that we're going to be issuing about the police department response to the Black Lives Matters demonstrations, in which there has been a raft of resignations of people who otherwise would have been investigated for their conduct in that, I believe we should and we must make such findings and make policy commentary on it. The rules do afford a former member the opportunity to be heard. I get the practical concerns about representation for former members of service whose unions may abandon them or they otherwise may not be able to have counsel. But that doesn't mean that I think we should hold off on investigating and commenting on severe acts of bias by former police officers. I think we should. That's what independent civilian oversight is, and we need a body in the city that does it.
So,
yes, if you could.
So I just wanted to speak to something about the term force. So Darius, if we could call on Darius, that might be helpful. But he was texting me and explaining that we use that term from the charter language for the.
Can you all hear me?
That's from Administrative Code 14151. Is Darius? Is he? Are you with us, Darius?
I'm here. Can you hear me? Can you hear me, or am I faint again? Trying to. Can you all?
Darius?
Yes. Can you hear me?
We can.
Is it muffled or?
It's faint, Darius.
Okay, let me.
Now. Is it better now or no?
Yes.
No. Microphone. Can you hear me now?
Yes, we can hear you now. You can go ahead and respond. The question is around the use of the word the force.
Force. So that definition for bias-based profiling is taken verbatim from New York City Administrative Code 14-151, which is the city biased policing statute that was passed in 2013. So we are just using that definition. So, city council use that language. They say, bias-based policing means an act of a member of the force of the police department. So again, that language comes directly from a city statute. It's not our idea, and we want to be consistent because again, that's the definition that is not only codified in city law, but I believe it's also the definition that is included in the NYPD's bias policing policy as well. So that's why we used it.
Okay.
I would just comment on that. 40 or 50 years ago, the police department eliminated using that because of the stigmatization that it caused, and because the city council was not sensitive to that language currently. I don't think we need to replicate that insensitivity.
All righty. I currently have 6 issues that that we have discussed. Thank you so much, Frank, for your thorough review of the rules. And I just wanted to open up to any other board members who had anything that they wanted to bring to the floor and see if based on any amendments motions for amendments that people want. I also should pause for a moment. I believe we've had another member of the board join us virtually.
Board Member Hogan, are you able to unmute yourself?
Yes, I'm available. I'm here. Hello? Yes.
Mute yourself.
Mayor Hogan, board member, Queens Representative City Council. And I've been listening, and I'm, I think ready to make my particular position on this. After hearing all that's been said, I agree with basically some of the stuff, has to be really looked at in more conversation, for me to okay anything. There's a lot of unclear language, that exist, and, in regards to the one particular conversation on, after there's an investigation, if the police officer is on the force, we live in a world that stuff follows us, and we should not be able to escape particular wrongdoings because we either retired or, change our life, the whole system exists on, people that have to become accountable for things that they've done in the past. And I think we be sending a really negative message to the public if we don't I won't say prosecute because we don't have that ability, but continue to investigate and find ways that wherever a person lands, some of the activities and actions of misconduct, if it doesn't, in a sense, follow him or her, from our investigation, there needs to be some kind of recourse where, you know, um, they understand because we'll be sending a bad message for the police officers that are in the department, and you can also have police officers that seem they're under a particular misconduct that might be substantiated, they retire and they free from it, and so that's only basically my comment on that.
Thank you so much, AU, for that comment and for officially joining the meeting with your introduction. So I want to, once again, if there's no other comments on the rules as presented, we have 6 different areas that were brought to bear. We did have a check with our general counsel in regards to to not using the term force and possibly using members of service or service. And so I will let John speak to where he landed on that. But just to remind folks that basically the process here is that if we do make any amendments to the rules, that they do have to go back to the law department, and we have 2 months that will take the process in order for us to rework the rules. So just wanted to make sure to restate that, as John has already presented to us. And John, if you can let us know what our general counsel said.
So I was communicating with the general counsel, Matt Gadushin, and he is of the opinion, and I agree, that if we replace the word force in the definition of bias-based policing in subchapter A, introduction, section 1-01 definitions on page 5, I believe if you're all looking at the rules, it is the 4th line from the bottom, and it is the second line from the end, the second word from the end of the line. If we replace the word force with the word service, that would be a ministerial change, and that is something we could do without restarting the process.
Okay. Alrighty. So thank you for that. The other issues that were brought to bear then would require a restarting of the process. And so basically asking if there are folks who want to make a motion based on any of the things that were already brought to the conversation.
Well, since I raised them, I suspect I do. So the first motion would be, I guess, the first 3, that we continue to use the language that's been used for, I guess, 40 some odd years, unsubstantiated, exonerated, and what was
investigate and
yeah, and that we immediately put after it with a hyphen or a colon or a parentheses, I have no strong feelings, the explanation, which would be unsubstantiated. Go back to my notes, excuse me. It would be unsubstantiated, colon, unable to determine, exonerated, colon, within NYPD guidelines, or law, I would put. And the third one would be unable to investigate, colon, complainant, unavailable. So that would be my first motion, that we make those 3 changes.
Okay. All right. Is there a second to that motion?
I second that.
Okay. I'm going to ask for a vote, and I'm going to go ahead and read a note for myself, just because I know there's some other members who are new to the board. So after we vote on this, just so you know, there's going to be a majority of the vote that's required in order for us to move forward. Just so you know that. probably pretty obvious, but I figured I would say that as well. So we have a motion on the table. It has been seconded. And so can I just, as a show of, I'm trying to figure out how we can, by a raise of hands, if we can say all who are in favor of the motion as presented. If I can have a show of hands. All right, and all of those who are voting nay against the motion, we can see a show of hands. Okay. And were we able to gather the vote from Mr. Freeman and from AU? Can they vote on virtually?
They're allowed to vote virtually.
Okay.
Mr. Freeman, you can unmute yourself.
Yes, I voted.
Who all received the votes from Mr. Freeman and from AU?
Yeah.
Jahira, did you hear the vote from AU and Mr. Freeman?
Just to make sure that we have it recorded for the minutes, I'm going to ask First Board Member Freeman if you could verbally vote, yay, nay, or abstain.
Abstain.
And Board Member AU.
You hear me?
Yes.
Okay.
Sorry, can you repeat your vote? Board Member Hogan, can you repeat your vote?
Did you hear me?
Now we can hear you. Can you repeat your vote, please? Sorry about that.
Yay.
So now, Chair Rice, we recorded 8 votes, 8 votes in the negative, and the motion does not move.
So I just want to be clear. There were 2 votes yes in person. There were 8 votes no in person, 1 abstention remotely, and then Yahira, I never got Mr. Hogan's vote.
Mr. Hogan, I want to confirm, I have you recorded as yes.
Yes.
So aye.
It's 3 yes, 8 no, 1 abstention.
Did you want to make a motion for the?
Well, do we require a motion to change force to service, or is that something we can just do by a claim, or?
I think we do need a go through.
I motion that we change the word force, bottom page 4, 4th line up, 2 from the end, to the word service.
Mr. Dwyer, if you could make it the bottom of page 5.
And also on the bottom of page 5, if it appears there.
I just think it's if we weren't going to have litigation, I would laugh, but I'm just trying to preserve the record.
Really appreciate that.
So I just want to be clear. The motion is going that the board will be voting on is that the word force in subchapter A, section 1-01 definitions of the term bias-based policing on page 5, 4 lines from the bottom, two words from the end of that line, the word force will be replaced with service. And that's what everyone's voting on now.
Second. All in favor? Aye. Okay, thank you. Okay. And can we have a verbal vote from Mr. Freeman and AU?
Yes, for Freeman.
Yes.
Okay, thank you. You?
Oh, yay.
So then that means we have nine in-person voting in the affirmative, yes, yay for the motion as presented, one voting in the negative for the recommendation, and then we also have on virtually we have one vote in the affirmative, no, two votes in the affirmative on virtually. Okay. Terrific. Thank you. The motion is passed. Did you want to make a motion on the other two, on the use of body worn cameras and then also the investigation of members of service for 5 years? Actually, first year shocks the conscious.
Yes, in order to bring greater clarity to the document, I motion that the Supreme Court definition of shocks to consciousness be included in the document in a way that the executive director determines most appropriate. Perhaps a footnote, perhaps I leave it to the discretion of the executive director where it would best go in, and that it will assist future members in evaluating what the standard of shocks to consciousness means.
Do I have a second? Yes. Sal, seconds? And we need to make a vote on we need to make a vote on the amendment. All those in favor? 2 are in favor. All those who are opposed, same sign. Okay. And then online, Mr. Freeman.
Opposed.
And AU.
Yay.
Okay. So I have on the record, those in person, we have 8 who are opposed, 2 are in favor. And those are those who are here in person. Online, we have 1 who is opposed and also 1 who is in favor. So that is declined. The next.
Given the high probability of success of my motions, I rest my case at the moment.
Yeah. All right. Thank you. Thank you for that. Anyone else? Any other issues, any other motions that anyone else would like to make?
Changes, regulatory changes as written.
Second. Okay.
As written or just as amended?
With the change in enforcement.
All right. Okay, great.
The ministerial amendments.
Terrific. And thank you for that second, Reverend Carolina. And as a result, we need to do a roll call. So we need to individually vote on the rules as presented with the amendment. And so I will model. And so I, Arbor Rice, am voting A affirmatively. Mr. Carolina?
A affirmative.
Okay. John? Mr. Siegel?
I vote to approve the new rules.
Okay. Kareem is Irish?
I vote affirmatively.
Okay. Mr. Rivadeneira?
I vote in the affirmative.
Okay. Mr. Puma?
I vote yes, affirmative.
Mr. Merritt?
Affirmative.
Mr. Dwyer?
Negative.
Sal?
Negative. All right.
Thank you. Has everyone voted? Mr. Freeman? Oh, I'm sorry.
Affirmative.
Yes. Thank you. Has everyone in the room voted? Okay, your votes have been recorded. Virtually, Mr. Freeman?
Affirmative.
And AU?
Affirmative.
Thank you. The motion is passed. The rules are now approved. Do we have any other old business to come before the board? Any new business to come before the board? Okay. then we will adjourn to the executive session.
You need to get a motion for that.
Oh, I'm sorry. Can I have a motion to move to can I have a motion to close out the meeting and move to executive session?
So move.
Can I have a second?
Second.
All in favor? Aye. Okay. All right, we're going to move now into executive session. The agenda for the executive session is the board will receive an update on litigation from the general counsel, and the executive director will provide an update on pending personnel issues. Do I have a motion? Oh, this is where I have it here. Do I have a motion? I believe that we have already decided we're going to move into executive session. So moved, and the meeting of the CCRB for today is adjourned. Thank you.